Mr. Speaker.
Simon O'Connor.
Next time. Mr. Speaker, I'm pleased to take a call on this official information Parliamentary Under-Secretaries Amendment Bill in its second reading. I want to acknowledge the member for his work to bring this to the House. I think it was noted by another member earlier. Getting one's member's bill drawn is quite something in and of itself. To have it then actually begin to progress through the House, particularly past first reading, is of note as well. Can I thank the Select Committee for its work on this? I do so for two reasons. First and foremost, I don't actually sit on the committee, but I have found the work that they have done and the discussions that have been generated through that very helpful in being able to inform my own view. I think a number of those members have spoken tonight and have discussed how via the Select Committee process, and particularly through listening to the submissions, that they have changed their mind somewhat. Look, I'm happy to go on the record that I'm uncomfortable with this bill. I am comfortable enough to, along with the party, vote for it tonight at this second reading. But the reasons for my discomfort I will elucidate a little bit more. I think first and foremost, though, we have to understand really the role of a parliamentary under-secretary. It's been part of the Westminster system for a while. It's explicitly acknowledged and written up in our Cabinet manual. It is in the Cabinet manual, but it's also actually within the Constitution Act 1986. And without belabouring the point for the House, Section 8 makes it very clear that the Governor-General can appoint a parliamentary under-secretary with the advice of the Prime Minister. I think this becomes quite important because there's been a lot of discussion tonight around the constitutional manifesting, shall we say, of a parliamentary under-secretary. Are they part of the executive? Well, as I would understand it, yes, insofar as they hold a delegation from a minister, but vitally important is that a parliamentary under-secretary is not part of the Executive Council. Now, I need to draw that out a little bit, and my colleague Brett Hudson had done so a little bit earlier. The parliamentary under-secretary, that's a power authority, is ultimately, as said, delegated from a minister. It's the minister in some ways, if I wanted to put it in very simple terms, giving part of their responsibility over, in this case, to another member of Parliament. That is quite distinctly different, though, than sitting on the Executive Council. A parliamentary under-secretary does not sit on the council, and the council, in turn, is that body of MPs who have become ministers of the Crown, who advise the Governor-General. Now, I'm not going to, of course, bore the House, primarily because most of them have sat on the committee, of why that's constitutionally important. But it does begin to raise questions about why this bill is ultimately necessary. Again, I might leave that point there for now. The second point, look, I think it is a good point on, the constitutional reality. It'll come back on the whole mission creep, which Mark Mitchell talked about. But I just think it's important to note that the OIA, the Official Information Act, has been specifically directed at ministers, and primarily, if not actually up till this bill, exclusively to those who sit on the Executive Council, in order, rightly and properly, that the Executive can be held to account. Granted, I must say as an aside, there is part of me that often wonders just how effective the OIA is. Granted, I haven't sat in opposition yet, so I will somewhat defer my thoughts, but I do see the enormous amount of work and effort that goes into generating paperwork, and I'm not really sure at times how useful that is, and in some other ways just how much time, effort and money is spent, particularly by civil servants, generating this. But as I said, I reserve my judgment. I haven't applied it completely and fully. Look, importantly as well, and the member for Epsom, David Seymour, was indicating tonight, and we do understand this, that his work as a parliamentary under-secretary is already in effect covered by the OIA. We know this for two reasons. Firstly, it's actually very clear that any person is able to approach the minister who's handed over that delegation to a parliamentary under-secretary and ask for the relevant information. And I think that makes absolute perfect sense. Again, you don't want ministers beholden to the OIA handing over responsibilities to a parliamentary under-secretary or anyone for that matter in order to escape the purposes of the OIA. So primarily we can see that you can already seek this information. So you begin to wonder what the point of this bill is. It's redundant somewhat. The second reason came through very clearly and very, well, by great illustration, shall we say, by David Seymour when he gave his presentation of just how much paperwork he was already providing. There is nothing that has been hidden here currently, and I think that's important to stress. Look, the other element, it's a little bit theoretical, but it's, and I'm no lawyer, and I'm a little bit nervous to raise this with lawyers in the chamber, but one of the basic precepts of law that I've understood over time is that it should never really be designed to address a particular individual. Instead, law should be designed actually to address particular behaviours, and most of the time that's what we do in our laws. Now, I'm sure an argument can be constructed that this bill is aiming at a behaviour, and we've heard a lot about open and transparent government, but I can't help but feel, and I think evidenced rather strongly, that this is a bill whose genesis has come about to target a particular member. Others have referenced previous debate points where it has been noted strongly that it's been focused on David Seymour. In fact, even the previous speaker alluded to it, and that is a concern. We've had it too, even with Chris Hipkins had spoken around, I thought slightly more eloquently, I have to say, or a rather refreshed angle about the whole, well, we want to get information on partnership schools, and we haven't been able to do that directly, so we've got to go through a person. I think a slightly cleverer argument, but one that still doesn't stack up. This is not the appropriate way to try and seek information on an entity. No, it's not about going through the OIA, but the whole idea that actually, well, we couldn't go directly to the organisation, or we weren't happy with dealing with the minister, so now we have to target an individual, I don't think is all that helpful. There was also, exactly, which of course you can already go to the minister too and receive that information, which I think completely highlights the point that this has become a bill focused on the individual and rather than a particular behaviour, and therefore breaking a pretty basic precept of law. And again, for those legally interested, the whole bills of retainers years ago were a good illustration of just how these things were misused. It also came up in one of the talks that actually if an entity gets government money, then it should somehow automatically be a focus of the OIAs. I mean, having worked in the likes of the Ministry of Social Development and so forth, where a number of NGOs and groups, charities and otherwise get government money, I'm not quite sure we want to go in that direction. I think that brings me, conscious of the bell, Mr. Speaker, to that whole slippery slope and mission creep. We have breached a constitutional line here. It's been very clear to date. We have breached a line here. Yeah, that's right. We have breached a line, and I do wonder where it ends. I actually hope that the SOPs that David Seymour has proposed are discussed. Not that I think they necessarily should go through, but I think they do begin to illustrate the point that if the OIA is just about open and transparent behaviour, that it's about people of influence, then actually it applies to just about everyone. Why shouldn't it apply to the Leader of the Opposition? Why shouldn't it apply to MPs? And I do have concerns when I think in recent weeks how the names of New Zealanders have been drawn and pushed through this House, and without good merit, but again, information has been sought, grabbed, misused, and I think we've seen that far too often actually, Mr. Speaker, where, knowledge about people's activities becomes an excuse, particularly for opposition parties, to have a crack at those people, often without good reason, and I don't think that's actually particularly helpful. I don't think that's particularly helpful to open or transparent government. So, Mr. Speaker, I again reluctantly vote for this bill. I do acknowledge the intentions. I do acknowledge the hard and good work of the Select Committee. I do acknowledge the conversations that particularly my colleagues from the National Party who have been on the committee have had, so I will vote in the second reading, but I'm interested in the further processes as they come forward. Thank you very much.
Claire Curran.